Hello, this is Matt on the Moon Family Sedan channel. The LBRY case has come to a complete conclusion at this point. You'll recall that LBRY lost their case with the SEC this past November, so we already knew that. But then there were hearings this January on the remedies portion of the case. And recently, in recent weeks, the transcript of that was released. We covered that as well here on the Moon Family Sedan channel. And today, the final verdict came on down. And the judge in the LBRY case, he kind of screwed us. So here's the deal. He punted the big issue, and to a degree, I'm not exactly surprised. He didn't want to come out. He'd already indicated, he said, I'm a minimalist. I don't want to, rule on something that's outside the scope of the case. And so here's the thing, though. He indicated that he would take, go out of his way to make sure that it was known that transactions outside of the LBRY offerings were not to be included in his verdict. In terms of the remedies portion right here, what was uncovered today, and to a degree he did, but not exactly with the vigor that I was hoping and expecting, and also. He didn't cover every way in which somebody could achieve the LBC token, the LBRY credit token, including if you purchase it. What he said. He said something about if you hold it. Okay, cool. What about everything else? It was a bit too vague, and this is not good for people in crypto. It's just more status quo type stuff. So if this happens in the SEC v. Ripple case, we're going to be a bunch of sad pandas. I'll tell you that right now. Now, I don't think that it's as probable for a broad array of reasons, which we'll be getting into in this video. And a lot of the circumstances are actually quite different. The charges, in fact, the allegations the SEC asserted are quite different, which I think, based on the allegations, which we'll get into in just a few minutes here, I think it makes it more probable that that Judge Torres, in her ruling, would have, a lot more to say about secondary market transactions as it pertains to XRP specifically, which is what matters most to us as XRP holders. I also have perspective from Attorney John Deaton, Attorney Jeremy Hogan, Attorney Bill Morgan, and Attorney Fred Rispoli. And this news just came out about 3.5 hours ago. At the time I'm recording this, it is 6:54 p.m. Central Standard Time, July 11th. And shout out and credit to Attorney James K. Filan for sharing this, and he tweeted this out at 3:14 p.m. So it's been just a few hours, but already lots of initial responses from all sorts of attorneys, including those within the XRP community. So I'm going to share with you what they had to say. And although I'm not exactly thrilled with what has gone down here, and it is more status quo type stuff, a bit of punting, it's actually not entirely bad. What happened here, there's a little bit of a silver lining, but I'll explain in a minute. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, I don't feel it necessary to actually read what's on your screen here, but in a nutshell, the final ruling, the penalties against LBRY are as follows. Don't break the law again. You are, literally, there's an injunction issued restraining LBRY from violating Section 5 of the Securities Act again. Also, they have to pay a civil penalty of $111,614. Now, why do they have to pay precisely $111,614? Because that's all they have. That's every penny to their name that they have right there. And if memory serves, I think the SEC was actually initially pushing for, I want to say, over $20 million. You have to fact check me on that. I could be off, but it was something, just whatever it was in the millions of dollars. And eventually they gave that up because, well, we're not going to get it anyway, so we'll just take every penny that you have. Here's what Attorney John Deaton had to say. I asked the judge to clarify that the token itself is not the security, just as Judge Castell did in Telegram. He declined to do so because he said that that specific issue wasn't litigated, and he believes in exercising judicial restraint. He wrote, quote, "It suffices to say that merely holding LBC or purchasing it for consumptive purposes is insufficient to bring third parties within the purview of the injunction," end quote. That's a lot more precise than what he was hinting at in January, isn't it? So, okay, you can purchase it as long as it's for consumptive purposes. What if it's for a different purpose? What if it's for speculation or anything else under the sun? So that's not included there. So just to be clear, it's not a surprise that he wouldn't say that the asset itself isn't a security. Attorney Deaton asked for that, and he had indicated, hey, the judge said, hey, I'm a minimalist, not going to do that. So we already knew that wasn't going to come. But this is a bit more limp-wristed than what I was hoping for. Anyway, Attorney Deaton continues. He said, quote, I take no position on whether the registration requirement applies to secondary market offerings of LBC by persons or entities not subject to the injunction, end quote. So there you go. He takes no issue. He takes no position. That's not what I didn't expect that sentence to be on here based on what he promised in January. And the transcript's available. I've covered it on this channel, damn it. No position? Well, thanks for nothing. Although technically it does help. Let me go a little bit further. You'll see why. Attorney Deaton says, he chose to punt the issue. I'm disappointed the judge wasn't more aggressive like he was in the November and January hearings, but he chose to be super conservative. The SEC can't argue his decision applies to the secondary market, however. That's better than nothing. And that would be the silver lining right there. The SEC cannot now argue that every transaction under the sun was included within this decision, which does seem to be the route that the SEC just wants to go in general as it's attacking crypto. They can't do that now because the judge went out of his way to say, I'm not taking a position, which means they can't assert that it applies to secondary market transactions. So while technically better than nothing, I'm not exactly thrilled here, and I kind of still feel like the judge screwed us all over. That's just how I feel. I'm just saying. Then there was this from my fellow XRP YouTuber Jungle Inc. He wrote to John Deaton and said, it seems like the SEC does point to LBRY in their Coinbase lawsuit, though. And Attorney Deaton says, yes, but they say the judge didn't distinguish between direct and secondary sales, implying he meant all. This, at least, declares he didn't include secondary sales because he took no position. It's weak, but better than nothing. So there you can see how this is actually, to whatever degree, even if small, it's going to harm the SEC's approach. Because as cited here, the SEC was pointing out, hey, in the Coinbase lawsuit, if you're looking at what happened in LBRY, because again, they cite what happened in LBRY, there's no distinction between direct sales and secondary sales. So if that's the case, that would be bad for anybody that wants to participate in secondary markets, because if it's included in the injunction, because there's no sort of differentiation coming from the judge, bad news. But the judge did throw a wrench in the works of that particular argument by saying, no, I'm just not taking a position. So it's pretty weak, definitely weak sauce. Oh yeah, you can taste that. Very weak sauce, but technically better than nothing. Jungle Link then responded and said, I guess from this guy, it's as good as we could have hoped for. And I do agree, unfortunately. I do agree with that. And then Attorney Deaton said in response to that, when you read the transcripts, the judge gets frustrated with the SEC, and in the moment of the argument, the judge is much more assertive and receptive, but when he gets to writing his decision, he strictly adheres to judicial restraint. It's the SEC's job to provide clarity, not his. His job, to him, is to rule on the narrow issues litigated. I knew that going in, and that's why I said on the record, Judge, I'm not asking you to do the SEC's job and provide clarity to the market, but you need to clarify your ruling. I had hoped for more, but feared this. I actually feared he might ignore us completely. Yeah, so that concept crossed my mind. I didn't quite share that same fear. I figured, he's on record here. He's going to say something. The question is, how is it going to come out? And this is worse than how I hoped it would come out. So it is what, I don't feel like I had particularly high hopes, to be honest with you, because he had already said, hey, I'm a minimalist. Okay, I got it. But this is not helping anybody. It really isn't. And then Jungle Link also said, John Deaton, is there any win in the fact that Odyssey wasn't included? Could this be a similar situation with XRPL2 LLC? And I think he means XRP2 LLC. I'm guessing, because Ripple has a registered money services business, and that's what they use to sell the XRP. It's just XRP, not XRPL. I'm assuming that's what he's talking about, unless there's some other organization I don't know about. But and then also Odyssey, they're talking about the video platform that that utilizes the LBC token. So again, he's saying here, is there anyone in the fact that Odyssey wasn't included in this? And could there be something similar here with Ripple and presumably with Ripple and XRP2 LLC? And Attorney Deaton says, this decision gives us nothing in Ripple. I think this decision may affirm the opinion of some attorneys like Attorney Mark Vagel and Attorney Jesse Hines that Judge Torres may not rule or comment on anything regarding secondary sales of XRP, as she could adopt a similar approach. As I've explained before, I understand why smart lawyers believe that. Ironically, the LBRY judge commented that he believed secondary sales were being litigated in the Ripple case. This decision, however, doesn't impact my belief that Judge Torres will at least comment on secondary sales, how far she goes, and then he's got a little shrug emoji there. Right, so I'll just say this. Judge Torres, she seems to be taking a different approach in general. I don't know, hopefully I'm not the only one that feels this way. I know I'm not the only one that feels this way, but the fact that she let John Deaton represent roughly 76,000 XRP holders, approved 17 amicus briefs ultimately, and then a couple didn't ultimately file, so I think the final number is like 15. Just wanting to take in everything, truly observe all this. And then more importantly, though, the fact that the SEC in this case, which is not what happened in the LBRY case, the SEC made assertions regarding secondary market transactions. Now, that's not what happened in the LBRY case. So, yes, the judge in the LBRY case, not so bold, not as we would have hoped, regarding secondary market transactions. But even he noted, hey, the SEC, in the SEC v. Ripple case, that is being litigated. And so this goes to what Attorney Deaton's been asserting. He actually does think it's likely that Judge Torres is going to address this. How could she not? The SEC explicitly brought it up. And so I see a lot of other attorneys saying, no, because it's not what needs to be ruled on. Okay, but the SEC brought it up, and that would be a part of how Judge Torres comes to her conclusion, would it not? Is she going to be so afraid to broach that subject? I sure as hell hope not. And it's possible. We could be very disappointed. But, we get the ruling, but I think, I'm just saying, it's way more likely for all of those reasons, I believe, that we would get some sort of decision on secondary markets, some sort of ruling from Judge Torres in the SEC v. Ripple case, which is exactly what we need. We need that clarity. And then we have this from Attorney Jeremy Hogan. The final ruling is out in the SEC v. LBRY case. The judge did not rule on secondary sales, or, not surprisingly, the major questions doctrine. He enjoined further violations and issued a penalty. So I'll just pause and note the major questions doctrine. This is highly relevant, especially after an EPA case, which came down from the Supreme Court in 2022, in which, in particular, I believe it was Justice Roberts that wrote the majority opinion, if I'm not mistaken anyway. But part of the decision that came down, a big part, was that, if you're going to do something, if you're a government agency and you're going to make a decision that's highly economically impactful, or it doesn't even have to be economically, but just highly impactful in various capacities. If you're going to do that as a government agency, you need to cite where you have congressional authority to do so. So with the SEC obviously engaging in tremendous government overreach, quite the jurisdictional land grab that the SEC is going for, the major questions doctrine is in play at this point. And so Attorney Hogan here is noting that the judge in the LBRY case, not surprisingly, didn't even mention it. It's a big nothing, right? Even though this is highly consequential. Which is why, again, though, but you can also see if this, if that were to go to a higher court and make it to the Supreme Court, you kind of wonder, okay, what would have been argued? Now, of course, LBRY is ultimately shutting down, so that ain't happening. There is going to be no appeal beyond this. But with Ripple, if Ripple loses, this is going the distance. Attorney Hogan continues, though. He says, is a similar result possible in the Ripple case? Yes, possible. But the court would have to find that there is not enough to the fair notice defense to have a trial on the issue. Also, the court would have to find that past and present sales of XRP are investment contracts in order to provide injunctive relief. The injunctive relief would be a big problem for Ripple since it would enjoin sales from escrow. But it's a problem with a possible solution. Just a workaround that might interfere with Ripple's business plans. No ruling on secondary market sales is a status quo ruling, meaning that I don't think Coinbase would relist, but I don't think other exchanges would delist either. So, folks, this is what, let's pause to think about this. This is a big part of what's at stake. If Judge Torres does not provide sufficient regulatory clarity for secondary markets, Coinbase may not relist XRP, along with talk about any exchange that delisted or halted the trading of XRP. They're not going to reverse that, potentially, if we don't get that. Because what would have been determined? Something specifically having to do with Ripple? Well, that doesn't answer the damn question that's important to investors and holders of XRP. That's what he's talking about here. That would be awful. Attorney Hogan continues. What I don't like is the deference the judge shows to the SEC in this final paragraph and his failure to understand the confusion in the marketplace. Very disappointed. Very disappointing, Attorney Hogan says. And this is what the judge wrote. And I think he's right, it really does illustrate the degree to which this judge just doesn't freaking get it. He wrote, quote, "Under the circumstances, I find that the imposition of a maximum statutory amount for a first-tier penalty is appropriate, especially since LBRY's misconduct continued after the SEC's position on the registration requirement became clear. Its violation is more egregious than a simple unregistered offering. The penalty is also necessary to deter LBRY and others from conducting unregistered offerings, while also taking into account LBRY's representations that it is without funds to pay a larger fine." So there you go. The judge proposes to deter others from doing what LBRY did. But that doesn't help anyone because it's not clear what the hell the damn rules are. We didn't even talk about secondary market transactions, not sufficiently anyway. What in the ever-loving hell? The judge just seems to not get it, or just doesn't care. And so then Hogan says, in conclusion, this ruling, and indeed this case, provides little market guidance and has protected no one. In fact, it hurt all the people involved. It's just another feather in the SEC hat, that's all. Yep, spot on, Attorney Hogan. Attorney Bill Morgan wrote, "No help to the market from this decision on whether the LBC token itself is a security. The judge sidestepped the issue and didn't entertain the major questions doctrine. The whole case achieved nothing except harm to one company and its employees. So much for clarity through courts. There is a real risk Judge Torres will also sidestep dealing with the issue whether XRP itself is a security in the Ripple case. I have always been pessimistic she would do so, although I accept there is more chance she will deal with it than Judge Barbadoro." And so that's Judge Barbadoro in the LBRY case. Yeah, well, I share the concern. I certainly, but I'm at a minimum cautiously optimistic that Judge Torres is going to address this because, again, the SEC brought it up. The SEC brought it up, and how could that not be substantially relevant to coming to a particular conclusion in this case? I mean, there's such an overarching theory, the embodiment theory. We're just going to overlook that substantial claim because you don't technically have to rule on it? Well, maybe. I mean, I'm not saying I have zero concern about that, but that'd be awful. Attorney Fred Rispoli wrote, "Keep in mind, the interest in Amici participation was nowhere close in this case as it is in SEC v. Ripple. The issue of secondary XRP is squarely before the court. I still think we get one better than in the LBRY case, i.e., XRP is not a security and secondary sales are not per se securities transactions, as the numerous Amici briefs have shown. Whether any particular sale of XRP is an investment contract outside of Ripple sales is not before the court and is for another day. This is not total victory, but would be a big win." So we'll see. Seems to be, optimistic. I don't know, folks. I'm just a bit disappointed by this. It could have been, he could have instead just literally not said a damn thing. That's the worst thing he could have done. And I didn't really think he was going to do that. And I've articulated that on the channel many times before. So he did something, but it's just way more wimpy than what you would have believed if you read the transcripts from this past November and January. That's all I'm saying. That's pretty much it. And then you have this from the official LBRY account. The final judgment in SEC v. LBRY is out. In accordance with the court's order and our promises, we expect to spend the next several months winding LBRY Inc. down entirely. As to what happens to LBRY from here, well, that's up to you. The LBRY network has 30 million pieces of content, 1.7 million on-chain identities, famous content creators, apps used by millions each month, quality open source code, the clearest regulatory standing of any token other than Bitcoin and ETH. Maybe the best is yet to come, ? And if you're wondering why you might say maybe the best is yet to come, well, as far as I can see, the Odyssey platform utilizing LBC, not impacted. It continues to exist. It is live today. The LBC token, decentralized, it's being traded today. In fact, I look at the price. Here, let me pull up a 24-hour chart for you, actually, here. So there you can see, it's actually up 9.65% over the last 24 hours. And you can see that, it's been coming down since, call it, 9 a.m. this morning, roughly. But that was before the ruling was even known, right? So we found out, I think we found out first from attorney filing, so far as I know. Somebody else announced sooner, maybe I missed it. So maybe that is what caused us to go down and I just missed it. I don't think so, though. I think everybody would have been talking about it sooner. So I do believe that it's more likely it was around 3 p.m. And the price barely did anything in terms of a dip. Wouldn't it be interesting if we get a terrible ruling regarding secondary markets in the SEC v. Ripple case and then the price of XRP is like, Because I just kind of figured if we don't get sufficient clarity that perhaps XRP would just tank, even if temporarily. So, but anyway, so the LBRY credit, it's not going to cease to exist because of this. So it's more like, this is how stupid it is. It's like the tokens, because they're decentralized, they're allowed to continue to exist, we think. We'll see what if the SEC can pull an embodiment theory out of its rear side and apply it to everything, right? But it's just so ridiculous and laughable because you can, if it is the case that LBRY is going to be allowed to continue to exist in the United States specifically, everywhere else we're not worried about this, right? But specifically in the United States and be used, it's just kind of funny, but in a terrible way, that you're not allowed to launch something that would lead to the creation of this because you get sued into oblivion. But once you do it and you're sued into oblivion, your creation can just, it's fine then. It can just continue to live on. Doesn't that just sound absurd on the surface? Anybody else grossed out by that? What a bunch of nonsense. Well, I'm sure there's going to be more thoughts and discussion on this, but that's, those are the initial responses here. That's what we got. What a joke. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.